Hello, everyone, and welcome to the latest episode of Legal Bites, the official podcast of Cummings and Cummings Law, where we focus on helping businesses and their owners redomesticate out of unfriendly legal and tax environments to more predictable pro entrepreneurship, pro growth states like Florida and Texas. Today, we are reviewing why dissolution, also referred to as termination, although those are actually two different things, but we'll stick with dissolution to keep the terminology consistent. Sorry, I digress. We are reviewing why dissolution is not an effective mechanism for relocating a company to a new state, why CPAs and attorneys who suggest dissolution in this context may be committing or at least exposing themselves to malpractice, and what you should consider instead. But first, a brief introduction. My name is Chad Cummings, and I am an attorney and certified public accountant serving clients in matters of business, tax, and commercial law throughout the states of Florida and Texas. I am Chief Executive Officer of the multi-state, multi-attorney law firm Cummings and Cummings Law. And in addition to my day job, I also teach business and tax law at the university level. I hold 4 degrees, including 2 law degrees, as well as a bachelor's degree in accounting and a master's degree in taxation, in addition to 11 professional licenses and certifications covering accounting, tax, audit, and of course the law. My firm website is www.cummings.law. Now, onward. If your CPA or attorney has advised you to dissolve your company in one state in order to move it to another state, you received bad advice. It is not malicious advice, it is uninformed advice. Most CPAs and even many attorneys have never heard of redomestication. They do not know the process exists. When I get on the phone with clients or prospective clients, often the first thing we have to do is unpack all of the bad or at the very least incomplete advice they received from other so-called professionals. When a client says they want to move their business to a new state, many CPAs and attorneys reach for the tools they already know, which in many cases is limited to dissolution or merger. Now, again, those may make sense in certain situations, but in almost every case, those are the wrong answers, and that wrong answer can cost you tens or even hundreds of thousands of dollars or more to fix, if it can be fixed at all. Here's what happens when you dissolve your company and form a new one instead of properly redomesticating. You terminate the legal existence of the entity. That is a big deal. The company's federal employer identification number terminates. The company's contracts, every vendor agreement, every customer relationship, every lease are now contracts with an entity that no longer exists. And all of that liability for those contracts and other obligations falls to you personally as the business owner. Let me make that clear. That means your house, your bank accounts, your retirement accounts, maybe even your kid's college fund is all on the line because you received bad advice. And in the event of a lawsuit, and by the way, lawsuits happen far more frequently to companies that have ceased operations or dissolved than many attorneys like to admit, all of those assets will be on the line to satisfy a judgment. Now, if you start a new company, you must renegotiate your contracts. You must transfer your assets. By the way, you're likely to have a tax bill from Uncle Sam. You have to close all your bank accounts. You got to open new bank accounts. You have to reestablish your credit, which can take years to rebuild, and start over from scratch. Your business credit history, which may have taken years or decades to establish, is gone. Your search engine optimization tied to the legal name and continuity of the original entity is disrupted. And as I alluded earlier, dissolution is often a taxable event under the Federal Internal Revenue Code and applicable state tax authority law. This means you may owe significant federal and state taxes on the dissolution itself. You have not moved your company. You have delivered the death penalty. and started a new company from scratch, and the IRS may send you a bill for making that decision. Now, redomestication does none of this. It must be distinguished from dissolution. The terms are not interchangeable. These are terms of art. Redomestication is the legal process, I should say the lesser known legal process, of transferring a company's state of domicile from one state to another without dissolving it, without creating a new entity, and without triggering a federal income tax, when performed in strict conformity with the Federal Internal Revenue Code, Treasury regulations, and the statutory frameworks of both the destination and departing states. In fact, the company retains its existing federal employer identification number, contracts, bank accounts, and credit history. There is no operational or financial disruption in redomestication. The same absolutely cannot be said for dissolution. In redomestication, the entity that exists after is the same legal entity that existed before. The legal domicile changes, nothing else does. This is possible because redomestication is a non-taxable event under the Federal Internal Revenue Code. The company's tax attributes, including a subchapter S election if one remains in effect prior to the redomestication, continues, and its basis and assets carry forward without taxable gain or any adjustment at the federal level. The reason your CPA does not know about this is that redomestication is a legal topic, not so much a tax topic, although there is certainly a relationship. And redomestication statutes are a creature of state law, which CPAs are not permitted to advise on. CPAs, and by the way, I'm a CPA myself, so I'm not trashing them, but you should understand, and your CPA should be absolutely transparent with you to the effect that CPAs are trained in tax and audit. Attorneys are trained in law. Few professionals hold both licenses, and fewer still have performed even a single redomestication. The result is that business owners receive advice from well-meaning professionals who are working with an incomplete picture. They recommend dissolution in some cases because it is the only mechanism they know. Or they recommend foreign entity registration because it seems simpler. Just fill out a few forms online, they say, famous last words. Foreign entity registration, in contrast to redomestication and dissolution, does not change the company's domicile. It keeps the entity domiciled in the former state and merely adds a second state of compliance with ongoing fees, reports, and tax obligations in both jurisdictions indefinitely. The company continues to exist under the former state's laws. The owner continues to owe taxes and filings in the former state in most cases. Now, the plan of conversion is the secret sauce in a redomestication. The plan of conversion is the foundational legal document that makes redomestication work. It is not a form. It is not a template. It is a bespoke legal document that authorizes the conversion, specifies how ownership interests will be treated, confirms that existing contracts and obligations will carry forward, and importantly, preserves the existing federal employer identification number in federal tax elections. Without a plan of conversion, documents filed with the Secretary of State have no real legal effect, or worse, can result in the inadvertent termination of the company. CPAs cannot write a plan of conversion unless they are also licensed as an attorney. In fact, that constitutes the unauthorized practice of law, which is a felony in Florida. Many online filing services and even some attorneys omit this all-important step, that step being the plan of conversion. That omission is the single most common cause of failed or defective redomestications, and fixing a defective redomestication can cost $15,000 or more if it can be corrected at all. To provide a recapitulation, if someone told you to dissolve your company, at best, they did not understand the question, and at worst, they may have exposed themselves to malpractice. Get a second and third opinion before you file anything. Dissolution is unfixable in many cases. The consequences are very real and totally avoidable when you work with an attorney who is experienced in this niche area of law. If you have questions regarding potentially redomesticating your existing LLC or corporation, please use the link in the description for more information on this legal process and to schedule time for you and I to speak one-on-one about your specific situation. Again, my name is Chad Cummings, and I hope that you found this information helpful. As always, the information in this presentation is general in nature and it is not legal advice, because legal advice, by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding this information or the content of any of my earlier presentations, please visit my firm website at www.cummings.law, not .com, but .law to schedule time for a consultation. I look forward to the opportunity to speak and perhaps even work with you very soon.